rise. The Court of Appeals Division 1 is now in session.
Please be seated. Thank you for being here today. We're here hearing our case 1CA CV180763 entitled Law Borgata versus Retreat. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal, but it's up to you to keep track of your time. That's why we have a clock at the podium for you. We are recording this argument, and I believe we're actually live streaming it. As you come forward, please identify yourself and your client, so when we review everything, we can keep everybody straight. The video will be on YouTube in a couple of days. We've read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the facts of the law. So when you begin your argument, just start out with what you want us to know and talk about. Counsel, you may begin.
Thank you. Good morning, Your Honors. My name is Joe Schenk. I represent the appellant La Borgata Apartments, LLC. And as the court is familiar with the facts, I'm going to skip through that part of my discussion and get to what I believe are the crux issues before the court. As the court is aware, this case involves a purchase agreement pursuant to which La Borgata was going to buy an apartment complex from the appellee Retreat at West Point, which I'm just going to call RWP. And the purchase price on that contract was $18,815,000. And the contract contemplated that the purchase price would be paid through a combination of the assumption of an existing HUD-insured loan in the approximate amount of $12 million and an additional $6 million plus in cash. That was the anticipated deal. For reasons that are disputed and were disputed before the trial court, the La Borgata was unable to secure HUD approval for the assumption of the loan by the scheduled deadline, which was August 30, 2017.
And was that a term of the purchase agreement?
The assumption?
Yes.
Yes, it was. But this leads us to the first issue, was whether the provisions in the purchase agreement requiring that a portion of the purchase price be paid through the assumption of the existing loan were for the benefit of the buyer only, because it obviously reduced the amount of cash that the buyer would otherwise have to come up with to close on this $18,800,000 transaction, or was it for the benefit of both parties? Because...
Well, counsel, is that the same term that required the one client to secure the approval of HUD and the lender?
It did require that contract provisions require, it contemplated that La Borgata, as the buyer, would apply for and seek assumption of the existing Love Funding Corp loan, and that they would get HUD approval for that assumption. And they did submit the paperwork. In fact, the undisputed facts were they submitted both the paperwork and the processing fees for both Love Funding and HUD were submitted to Love Funding in early June, 2.5 months before the ultimate deadline for closing escrow. So they did do all of that. For reasons that, as I say, are disputed, Love Funding did not process in a timely manner the its approval for the assumption of its loan. And as a result, on August 28th, 2017, 2 days before the closing deadline, HUD issued a letter which said it was not going to be approving the assumption because, number one, the lender, Love Funding Corp., had not yet approved it. And number two, because Love Funding Corp., the existing lender, had informed it that it was not going to be forwarding HUD's review fee to it until after Love Funding had completed its review and approval.
So counsel, the purchase agreement says, this is what I have written down, no transfer of any interest in the property under this agreement shall be allowed or effective prior to such approval by HUD. Okay, so that term is one of approval, correct?
It is.
All right, so the requirement, the promise is that you will get an affirmative go from HUD. Is that term solely for the benefit of one party?
Well, Your Honor, I think that is an issue that is not necessary for the court to address, because ultimately, the big question is, as the facts show, before the closing deadline, La Borgata offered to tender the full $18,800,000 in purchase money in cash to pay the entire purchase price in cash at closing. And that tender was rejected, again before the deadline, by RWP.
Cancel, but that doesn't make very whole, because there are consequences for not obtaining HUD approval as far as the people who work for Retreat, correct?
No, incorrect, because as we have cited, we cited the language of all three agreements. The contention was that HUD could impose sanctions on RWP if it transferred the property or did anything without HUD approval. But all of those documents, there's three documents, the note, deed of trust, and a regulatory agreement that were signed by RWP. All three of those agreements contain language, and we cited it in our reply brief, that said that all of HUD's rights, obligations, or restrictions under those three documents went away when the note was paid. So the only way that HUD would have been empowered to sanction RWP for not getting its approval is if RWP failed to apply a portion of the $18 million in sale proceeds to pay off the HUD-insured note. Keep in mind that HUD was not a lender, it was an insurer. It got paid a fee in order to ensure that Love Funding would not suffer a financial loss if the borrower, originally RWP, failed to pay the note in a timely manner. And well, what would a prepayment of the note have done? It would have eliminated HUD's insurance risk entirely, because there would be no possibility for a default. The note would be paid in full. And that's why all three of the documents specify that HUD's rights vis-a-vis the transaction went away, were terminated once the note was paid.
But didn't it also create a situation where there would be a prepayment penalty?
It did, but that's a separate issue, and I've got a response for that too, Your Honor. But ultimately, this whole HUD thing was a red herring, because as long as they paid the note off, there was no sanction exposure there. I even attached, because RWP in their responsive brief cited to the online HUD regulations, I attached in our appendix to our reply brief a portion of those regulations that talk about one of the ways that the HUD rights can go away is through the prepayment of the note.
Can you answer Roger's question though about the prepayment penalty?
Yeah, and let's get to the prepayment penalty then. The short answer there is that, yes, there was a provision in the love funding note that have cost a prepayment premium in the event that the note was paid early. There are a number of arguments as to why that would have been unenforceable, but let's go beyond that. The real issue here is that we were never told. After La Borgata tendered or offered to pay the entire purchase price in cash, the response they got back from RWP said nothing about concern over a prepayment premium. Their sole discussion was basically about, well, that's not what the contract says, and we got the Nelson v. Cann case that deals with that issue. Well, and secondly, that, well, we got this concern over HUD, which I've already addressed, which, because HUD's rights would have gone away if the note was paid in full. So if they'd have told La Borgata that, well, we're not going to close because your tender is deficient because it doesn't, protect us from this prepayment premium exposure, there are things that La Borgata could have done to cure any deficiency in tender. For one thing, it could have tendered the additional $600,000 or so into escrow to cover the full amount of that prepayment premium, which they would have been stupid not to do because the alternative would be to walk away from a $500,000 earnest money deposit. So given that this was an $18,800,000 transaction, the notion that this client would have balked at paying a $600,000 prepayment premium in order to go ahead and close a transaction certainly is something that cannot be assumed as a matter of law.
But why isn't RWP or any seller entitled to make whatever term it wants to effectuate the sale as long as the buyer agrees? And you brought up Nelson. I read Nelson to mean that all that was material in Nelson was getting the payment. Yeah. Whether they got it by a loan, whether they got it by cash, didn't matter to the seller. But here, all of the intricacies regarding HUD and possible sanction and the prepayment penalty were important matters to RWP, and why can it, as a matter of contract, require that the buyer meet the terms of the agreement?
Because the law in Nelson v. Cannon is that if a contractual provision or provisions are for the sole benefit of one of those two parties, the party whose benefit those provisions are for has the right to unilaterally waive them. And Nelson v. Cannon factually is very similar in the sense it was an apartment complex purchase that contemplated that the purchase price would be paid via assumption of an existing note, the addition of a new carryback note and two promissory notes and some cash. And it turned out that the existing lender would not allow a subordinated lien, so they couldn't pay a portion of the purchase price with a new carryback note. And so the buyer says, fine, I'll pay cash. They sued for specific performance, much like we did. The trial court granted summary judgment for the seller, much like happened in this case, but the Court of Appeals in Nelson v. Cannon said no, that provision requiring the assumption of, or the creation of a new carryback note was solely for the benefit of the buyer, because the seller's real interest is just getting the purchase price.
So counsel, I want to follow up on Nelson, but you're pointing to a provision in the I guess it was the non-recourse language in the note, and that is in 8A. But what about 8B of the note? Isn't that the operative part that your colleagues rely upon for their argument that there is a personal recourse liability? Are you focusing on 8A when you should be focusing on 8B?
I think that the problem there is that we did argue those issues, but if you're talking on the regulatory issues, what I'm saying is if you look at...
No, I'm talking about, we're talking about, the large question here is benefit burden. And so here, we had asked you questions about personal liability that might befall your adversary, your colleague, if they didn't secure HUD's approval. And so you said, actually, if you look at the document, there is no such personal liability. It's get out of jail free card and you get to go forward. But your colleagues say that you're focusing on 8A of the note when you should be reading 8B, which is the one that provides personal liability.
True, but again, we've kind of moved on from that argument too. That was made in our opening brief, although we also made additional arguments which we expanded on in the reply brief. If you just set aside the question of whether it was recourse or non-recourse, look at the substantive language that we quoted in our reply brief in both the note, the deed of trust, and the regulatory agreement. All three of those contain language that say HUD's rights and obligations regarding those documents terminates upon the payment of the note. So if the note's paid, HUD loses any authority to sanction the RWP or its principals.
So does 8B not say making it retreat and Mr. Waschak personally liable for damages resulting from a transfer without prior written HUD approval?
If there were any damages, but the payment of the note,
That's a yes, it does?
Yes.
Okay.
Yeah, I'm not arguing that. I'm saying that...
Okay. And now looking at that, and looking at this case through that lens, that if HUD approval isn't secured, we have two parties on the hook. How does that mean that the burden is exclusively upon and waivable by one party? Because
if the proceeds, the sale proceeds are used to pay off the existing note rather than the one that was to be assumed, under the contract documents between HUD and RWP, HUD acknowledged that its rights, obligations under those documents was extinguished when the note was paid. So its insurance risk was gone. As a practical matter, it would have had no reason to penalize RWP because RWP had ensured that it was never going to be called upon to pay out on its indemnity.
And then let's jump real quick to
I'm
Nelson.
going to have to reserve some time, and I'm sorry. If I didn't have the time, I would be happy to address, but I do want to talk briefly about Section 248 of the restatement, because that deals with the prepayment issue.
Counsel, I have a question. So on Nelson, you said that's factually similar or identical, but wasn't the deal in Nelson three parts? You had a cash payment, and then you had a third-party lender, and then you had a loan. The seller was making a loan.
Well, technically, there's a four-part because there's also two promissory notes that were going to be paid out to the brokers. So
right,
four components.
So wouldn't Nelson be more like this case if that lender, that second prong of the deal, refused to provide permission or would penalize the seller if they went through with the transaction, rather than the lender saying, we're fine with the sale, we just don't want more debt thrown on the property?
And I guess the reason it's similar is this. Because if you look at the true risk, not the professed risk, there was no risk, no HUD risk here as long as the existing note was paid off, because by contract language, HUD terminated its, its rights and obligations under its agreements with RWP upon payment of the note. With respect to the prepayment premium, it's basically an estoppel or bad faith argument under Section 248 of the Restatement of Contracts, which basically says that if someone makes a tender of performance that is deficient and the other side gives an, quote, insufficient reason for rejecting the tender, that they cannot later come back and claim that the tender was deficient if the tender was such that could have been cured had they given the correct reason for rejection. To apply that, provision of the restatement to this case, had RWP responded to our offer to tender all of the purchase money in cash with a statement, well, we won't accept that because we're going to be out an additional $600,000 for a prepayment premium, then we would have had the option to say, well, we'll cure that by tendering an additional $600,000 to cover that so you don't have any financial loss and no benefit loss, and that will make you whole. But because they didn't give us a sufficient reason for rejecting our cash offer, they are not now in a position to say that the failure to offer to pay the $600,000 prepayment premium made our tender deficient. And I've got 23 seconds that I'm going to save.
Thank you, counsel.
May it please the court, Jeffrey Messing. I have Keisha Hodge with me from my law firm for the defendant appellee retreat.
Counsel, can you talk about the harm to RWP?
Sure. This was a recourse note for any violation of the HUD and LOVE funding pre-approval requirement. Let us keep in mind that for LOVE funding to even pre-approve a prepayment, the note requires that they be given 30 days advance notice. The proposal to pay this in cash was made after 5 o'clock the day before closing, and retreat was given until 9 o'clock the next morning in which to agree to accept the prepayment without the prepayment penalty in exchange for clear title. Keep in mind that the purchase agreement provides that there are permitted exceptions. Retreat wasn't required to give clear title. Retreat was required to give the title subject to the note, the deed of trust, and the regulatory agreement. Now, with 8 hours before closing, La Borgata says, oh, we'll give you the same $18.8 million in cash, but we want you to get in 8 hours after the close of business the releases and consents from HUD and LOVE funding that we couldn't get in 10 months.
Well, counsel, what if La Borgata had said, you know what, we'll give you the purchase price and we're going to throw in that penalty. We're going to cover it for you. Isn't that really, in that instance, possibly a waivable term?
Your Honor, you're asking me to speculate what would have happened
Let's speculate.
if at that point retreat had gone back to LOVE funding and said, I know the agreement required 30 days advance notice, and HUD, I know it requires your written pre-approval, but we've already sold the property and taken the risk of criminal and administrative sanctions personally and to Mr. Waschak. So please, after the fact, approve what we've already done, despite the fact 2 days before, HUD's lawyer has, on a recorded telephone conversation, told Mr. Waschak that if he does it, that the HUD enforcement agency was going to take action against them.
So there was more than cash at stake. There was liberty at stake. And how was, I guess, how would they have compensated you
They couldn't,
for that?
They couldn't, Your Honor. They could not. Nor could they compensate an entity that does regular business with HUD. This is not the only HUD-insured loan that the principals of retreat have ever done. So now you're saying, okay, we want you to jeopardize your entire business relationship because we want you to change the deal after business hours, the day before it was supposed to close, with no prior notice to Love or Love Funding or HUD. That is not reasonable, Your Honor. That is not an offer. That is not a tender. That is an offer to renegotiate a contract when it's too late to do it.
Okay, counsel, if the loan note is paid off in full, what possible sanctions could HUD put against your client?
I don't know the answer to that, Your Honor, and neither did Retreat. And would you advise a client to take the risk of criminal administrative sanctions because you're comfortable that they're going to win the argument in litigation down the road, that no harm, no foul, HUD, so ignore what your agreement actually says, ignore your regulations, ignore the fact that your approval has to be in writing prior, ignore the fact that Love Funding is entitled to 30 days advance notice of a prepayment? Would you advise your client to take those risks? I wouldn't. And Retreat wasn't willing to take those risks.
Cancel to go even further, even if your client was assured that they would win in the end, they may not want to go through all that.
Sure.
Litigation.
How much are they going to pay me to litigate with HUD? How long is it going to take? What is HUD's internal administrative people going to think the next time Retreat's principals come and say, hey, we've got another apartment complex loan we'd like you to guarantee? Yeah, you're the guys who sold the prepayment and we just got done litigating with. That's a good way to ensure your future business. I mean, Your Honor, I don't mean to be facetious, but after 10 months of assuring Retreat that La Borgata was going to perform, sure, we're going to get the HUD approval that we're required to under the contract. The day before closing, they say, oh no, we can't get the HUD approval, so we're going to give you cash. And now to say, oh, well, you should have come back and renegotiated with us to tell us that you not only need the cash that we've offered, but that you need the prepayment penalty. And by the way, the fact that now you have the burden to go and get the releases and clear title that were La Borgata's obligation under the purchase agreement, well, we'll just ignore that. Because remember, Your Honor, this is not just as in Nelson. Oh, okay, here's the full amount of the purchase price, we're done. No, this was, we want you to give us clear title. You go get the releases. You get HUD to release its regulatory agreement. You get Love Funding to release its deed of trust. And you do that by tomorrow. That's not possible, Your Honor. That's an illusory offer.
Well, what if it was by next month? What if it was more? Is your problem with the timing, the short fuse, or is it with the substance?
My problem is with the substance, Your Honor. That's not the deal that we negotiated 10 months ago. And now for you to come to me on the 11th hour and say, we want, I mean, because remember, this counteroffer that they're making now is not the first offer. The first offer is, we want a third extension. 10 months wasn't enough. And remember the backdrop that this comes against, Your Honor. This is repeated defaults. This is not just, hey, it's no fault of ours. I mean, a counsel stands up here and says, oh, it's disputed as to, why Love Funding and HUD didn't give the approval. Your Honor, the standard under Orem School and its progeny is it has to be a genuine dispute of material fact. Here are the undisputed facts, Your Honor. The agreement gave them 10 months, including 2 extensions, to get these approvals. They submitted their initial application on, I believe it was January 26th. It was rejected by HUD on January 26th. Under the agreement, they had 14 days to cure the defect and resubmit. 14 days, Your Honor. That would have been February 13th. They waited until June 4th, 4 months. That initial resubmission on June 4th was also defective. They acknowledged it was defective because it didn't include the hard copy. They promised to have that later in the day or tomorrow. When they hadn't given it to them by June 12th, HUD say, where's our hard copy? We can't start without the hard copy. On June 28th, La Borgata goes back and says, oh, we're still working on it. We'll get it to you. They followed up again. HUD followed up again on August 21st. Still no hard copy. La Borgata did not finally deliver its hard copy, the first step to start the process, until August 23rd, 7 days before the closing. Your Honor, we're talking about a party who has been in default without telling Retreat for almost 10 months. And then, after they've dragged their feet through this entire process and breached obligation after obligation, they come to Retreat the day before closing and say, we want a new deal. Your Honor, that is not reasonable contract performance. That is not a reasonable tender of performance. That is a bad actor who has not performed under the contract saying, we don't care, we want you to renegotiate the deal because we asked. Under those circumstances, the case law is clear. I think we cited the case of Bolo for the proposition that parties aren't required to renegotiate contracts. You're entitled to require performance according to the terms of the contract you negotiated. And the fact that La Borgata is in breach doesn't give it, that's not a restatement section 248 defective tender. That's saying, I want to renegotiate the contract. And a party is not obligated to renegotiate its contract because the other party failed to perform. That's what contract law is about. You're entitled to say, I want the performance I contracted for. I don't want to have to go and spend my time and my money getting you releases from HUD and Love funding. That's an obligation that you undertook and was built into the purchase price. You want to stand here and say I'm obligated to renegotiate the purchase price? Well, not only do I want the prepayment penalty, maybe I want the money that I'm going to have to spend getting the approvals. Maybe I want you to reimburse me my attorney's fees. Maybe we renegotiate the whole deal. A seller's not required to do that.
Right, well, that's not this case. I mean, we have a term, and your colleague is saying the term is waivable. Because that term is, or used, or is to benefit his client. So we look at the term here. What is the term that is at issue? And does that, not sort of questions of reasonableness or unreasonableness, does that solely benefit your colleague's client, or does it impact both?
It impacts both, Your Honor. As you've already acknowledged, the documents impose recourse liability on Retreat and Devin Waschak for transferring the property without HUD approval. They didn't contract for taking the risk that HUD may or may not agree that tendering the cash is good enough. That's a risk, Your Honor.
Right, I understand. So it's a risk, really, if we're going to monetize, and I understand there are liberty questions, if we have a criminal penalty.
And administrative sanctions, Your Honor. They could be debarred from doing business with HUD anymore.
Right. So, but is it fair to characterize them as speculative, the monetary consequences?
We don't know, Your Honor.
Well, so it is.
And the point of contract negotiations is I contract for certainty. I don't contract so that I take this money and take the risk that I might go to jail, or take the risk that I may have to spend another $100,000 in attorney's fees fighting with HUD. I contract so that I know what I'm getting.
So the benefit is the absence of risk.
Exactly. That's why we enter into contracts, so that I know what my risk is. I know that if you default, I get the $500,000. I know that if you perform, I get my net equity in the property, and I'm done. I don't have to take the risk that I'm going to go and litigate for the next 3 years with HUD over whether or not I've adequately performed under the terms of the regulatory agreement and the note and the deed of trust.
Did your client, though, have an obligation to inform about that risk, that you were looking at the prepayment penalties, that those were involved based upon
It's not just the prepayment penalties, Your Honor. It's the need for HUD pre-approval.
I
And
understand, but did your client have an obligation to inform of those possibilities of the prepayment penalty, of the personal liability based upon?
Your Honor, they knew all of them. They had the risk. If you look at the documents we attached to the documents below, they calculated the amount of the prepayment penalty themselves internally. They're well aware of all of this.
Okay, so you don't think at the time that, at the end there in August, that there was an obligation on your client's part to inform them that we're rejecting this in part because we're facing this possibility of prepayment penalties, policies?
Your Honor, no. I mean, a defective tender is you come in and you say, okay, here's the payoff on the loan. And I come back and say, oh, you miscalculated the payoff. Not that you're changing the terms and you're giving me the same price and now I have to give you clear title, which is not what we negotiated for, and I have to take the risk that HUD and Love Funding are going to come back after me. That's not a defective tender. That's renegotiating the basic terms of the contract. Those are two very different things. Plus, by its very nature, a defective tender presupposes that the party making the tender can cure it. How do you cure my risk of HUD administrative and criminal sanctions, Your Honor? You can't. You can't indemnify me against it.
Let's take that HUD gloss off. And we'll say we have a traditional lender with no HUD. Do you win or do you lose?
It depends on what the terms of the note and the deed of trust
Let's
are.
say it's the same, everything's the same except there's no HUD gloss.
If the only term is the prepayment penalty, I think I still win because what they're doing now is on the eve of closing, they're telling me that I have to come up with the releases and I have to go back and tell them, no, the payoff amount is X, including the prepayment penalty. Keep in mind, Your Honor, they have the same note. They know about the prepayment penalty. So I don't think, I mean, this was a last-minute Hail Mary, throw it back on the other side. Hey, you wouldn't give me a third extension. How about if I pay you cash, hoping that we'll counteroffer and negotiate a new deal? This is not a defective tender situation, Your Honor. This is a situation where what they wanted was a new deal because they couldn't perform the old deal.
And give me what your best reason to distinguish Nelson. Why isn't Nelson controlling here?
Because in Nelson, there was no personal liability either for a prepayment penalty or for failure to get HUD and Love Funding pre-approvals. I mean, this would be similar, Your Honor, there are notes out there that cannot be prepaid. I mean, there are situations in which the lender says, no, this is a favorable interest rate. I want it for the next 10 years. You're not allowed to prepay this note. That's essentially what this note was. That's why there's a prepayment penalty built into it. Because if you pay it off before, I forget, it's 2020 or 2022, you have to pay a penalty because the lender wanted to guarantee that it was going to get its entire stream of payments. That's what differentiates this from Nelson. In Nelson, there was no prepayment penalty, and let alone civil and criminal administrative sanctions. Plus, Your Honor, you really can't ignore the continual breaches by La Borgata. This is not a party who has been performing in good faith for 10 months who comes in and says, hey, we got a little hiccup at the end. Can we do this instead of that? This is somebody who's completely reneged on their contractual obligations for 10 months and wants to transfer the risk of their failure to perform to the seller. I mean, a rational businessman is not going to look at these people and say, yeah, this is somebody I want to renegotiate my contract with in the 8 hours after close of business between now and closing. Do you want me to talk briefly about their arbitration argument? The bottom line, Your Honor, is that at the time that this lawsuit was filed, Rule 8C was specifically had language that made it clear that the list of affirmative defenses is not exhaustive. Cortez holds that mandatory arbitration is an affirmative defense. They did not allege it in response to the counterclaim. And worse still, Your Honor, and this is the point that I think deserves to be emphasized. When they filed their amended complaint, they specifically asked for contract damages. And it wasn't until they filed their response and cross motion for summary judgment that they argued, and I'm referring to Section E on page 18 of their pleading below, that it was not responsible for HUD's denial of approval of its application, and that the escrow should be returned to La Borgata. That is, it explicitly argued that it would arbitrate its claim only if and when it lost in Superior Court. What it was asking for was, and what it's asking for in its appeal brief, Your Honor, is 2 bites at the apple. It affirmatively asked for the same escrow deposit that Retreat asked for, and then said, oh, but if we lose, we want to go arbitrate. You don't get to do that. That's the holding of Polo Corp versus Holmes and Sons that we cited in the brief. If you have questions, I'm happy to answer them.
Thank you, counsel. We appreciate your argument. And counsel, before you begin, I'll ask the bailiff to bump your time up to a minute.
Thank you. All right, I'm going to use the last minute to address the alternative argument that we've made in our appellate briefs, which is that even if you find that the tender of cash by La Borgata was deficient and therefore RWP was under no obligation to close, there is still a factual issue as to who is entitled to the $500,000 earnest money deposit. The purchase agreement basically provides, and I put it in the brief, that you look at the letter issued by HUD that denies assumption, and whether or not it was the buyer's fault for HUD's failure to accept or to grant the assumption. And in this case, the letter cited 2 reasons. One was that Love Funding hadn't completed its review, and the second was that Love Funding had not forwarded the review fee to HUD. It didn't cite anything about untimely submission of a hard copy. It didn't cite anything about any shortcoming on the part of La Borgata. The letter on its face attributes the reasons for why it did not grant timely approval to Love Funding, not to La Borgata.
Thank you, counsel. Your time is up. We appreciate your arguments today, and we'll issue a decision in due course. We're going to stand at recess at this time, but we're going to remain on the bench for the next case and the next counsel to come forward. Thank you.
Thank you.